voluntary. We won't cover any cases, we won't cover any material. We will simply talk about the exam strategies, etc. So obviously we know what we're getting. Let's see. I don't think. Oh, one other thing. At this point, anyone who has sent me an answer to one of the sample questions that I've sent out, I will definitely be able to get to yours. So rest easy. If you send me any answers from this point on, I am not making that promise because the time is short. I will try, but with this weekend, me being out of town at moot court, that time is gone. That is not going to work. That takes us into next week, and at that point with Thanksgiving and all that, I just can't promise. So you're more than welcome to submit them and cross your fingers. And obviously, if you're going to cross your fingers, then the sooner the better. That'll give you your best chance. Okay?
If we don't get a chance to write one up, can we just come by your office to talk to you if we have questions?
You can, but that's obviously less useful
Yeah.
than actually getting direct feedback on an answer in a time setting and all of that. But yeah, again, you will find as we get closer to finals that there sometimes tends to be a line outside of faculty members' door. So, you'll be like, how long can I wait? So, I will have extended office hours and all that leading up to the final, but, it can be hit or miss, unfortunately. But I'll try to be as accommodating as I can. What ends up happening a lot of times is I'll take especially once you finish one exam and you start to focus on the next one, once you're focusing on mine, I'll end up taking groups of 3 or 4 or 5 of you in my office at one time, and we'll just talk as a group, because that's the easiest way to sort of get everyone's questions answered. And then, of course, bringing your questions to the review session is another way. So there'll be lots of different opportunities. But getting a chance to talk about one of the practice questions may not be as easy as I would like. Okay? Anything else? Okay. I want to sort of finish up our discussion of Leidholm by calling attention to or coming back to one of the elements of self-defense that has traditionally been critical, and that is imminence. And I want to sort of review this idea, or one of the sort of challenges for the defense lawyer in a case like Leidholm's, which is the question that any reasonable prosecutor is going to pose, and that is, how can the threat that you are facing be imminent? And indeed, how can you even believe that it was imminent, and reasonably believe that it was imminent, if the person was asleep? If you're the prosecutor, you're going to say, the threat wasn't imminent, at most it was hours away. And if it was hours away, you could have, we tie imminence to necessity. If the threat isn't imminent, you could have taken other means to deal with a non-imminent threat. You could have just gotten in a car and gone far, far away. A relative, a hotel, etc. So if it's not imminent, and there's good reason traditionally the law has required imminence, how can you have a reasonable defense? How can you have a defense of justification?
All of the alternatives that the prosecution puts forth may not have been options for her.
What do you mean?
Well, in a domestic abuse situation, it is not uncommon for the abuser to cut off any access to finances or to relatives. So Leidholm may not have had those options to go to.
And that's where I want to go to talk about this issue. One of the sort of developments in the law of self-defense over the last 25 to 30 years or so has been this idea of battered women syndrome. and its place in the law of self-defense. And one of the things that has developed as the law has trended in this area has been the need and the defense side being able to successfully in most states, including Kentucky, get the opportunity to do is to introduce expert testimony about battered women's syndrome and how it creates a situation in which a woman, almost always a woman, in these relationships feels that there are no alternatives and that the threat is always imminent. And the reason an expert is needed, you may be aware or you may not because you haven't taken evidence yet, that expert testimony is only supposed to be admissible on issues that are not within the normal, ordinary understanding of a reasonable jury. That's why you need an expert to testify, whether it's a scientific issue or a technical question, ballistics, right? Most of us aren't really experts in how to decide what particular gun a bullet was shot out of. That's why we have ballistics experts, fingerprint experts, who can look at the particular patterns of a fingerprint and decide, oh, was that from this particular person, and explain to the jury how that conclusion was reached. So those are some, just examples of the kinds of things you might need an expert for, right? On this, the argument made by a lot of prosecutors was we don't need an expert. This is something jurors, because they're supposed to be the sort of the judges of what's reasonable. They can testify to this. They don't need an expert to this. The juror can just decide what was reasonable. Okay, but the expert is needed to explain to people who have not suffered through these situations why, for example, a woman wouldn't leave, right, through a long-standing pattern of abuse. Jurors would ask the question, and prosecutors would ask them to ask the question, if it was so bad, why didn't she just leave? And thus cast doubt on the woman's testimony that it was that bad, that it made her feel like there were no alternatives, that it made her feel like the threat was always going to be present and was always imminent. So the expert says, we have studied this. We have studied this, and we have found that there is a pattern of what is known as learned helplessness. You have recurring patterns of abuse and contrition. You have attempts at escape, through which the woman says, I tried to call the police. He stopped me. We see that in Lydholm. Right? I tried to get therapy, and he stopped me. He threatened our children. Right? All of these circumstances put the woman in the position that she does not believe there is any recourse. She also, because she believes she is helpless, believes she can't resist him or take any action in self-defense unless he is in some way not a threat in that moment. That is, for example, he's asleep. Right? If you believe that this person has ultimate and complete power and control over you, you can't react in the moment while they're having an argument, while he's hitting her. You do it when? While he's asleep, because that's the only time you can overcome this aspect of the syndrome, this cycle to which you are subject to constant abuse. So that's what the expert testifies to buttress her testimony that she was suffering from this, that was the nature of their relationship, and it explains the situation. Mr. Wiseman.
This doesn't have to do with the alternative, but could you by chance turn the light up there? It's kind of hard to see.
I think I turn them on as much as I can,
Okay.
but let's try.
It seems a little closer.
The second one.
Yeah.
Is that better?
Yeah.
Technology is just a... Okay? So that's how this law has evolved. And one of the things that it's done is called into question the relationship. Well, it's done two things. One, it's called into question the relationship between imminence, which we talked about the other day, and necessity. that if we want self-defense to be a law of necessity, it may not make sense to use imminence as the proxy for that. That Bader-Women syndrome may sort of tell us, or suggest at least, that there are circumstances in which not even non-imminent threats may give rise to necessary uses of force in self-defense, at least in some circumstances. Now, you want to make sure the defense has to prove necessity, but we do not want to make imminence an absolute requirement. And the second thing it suggests, oh, it is much lighter up here, is to think about reasonableness and the relationship between subjective and objective. And how we capture that, what kind of jury instructions, and what is the best policy in our law, right? Traditionally, the law of self-defense and most areas of criminal law have looked for objective reasonableness. We don't make the test subjective. What would a reasonable woman have experienced, right? And we just say a reasonable person. The law used to say a reasonable man. We have gotten away from that. But do we want to make it, and how far, if we want to make it subjective, do we want to go to make it subjective? Do we want to say a reasonable person in the victim's position, or in the defendant's position if it's an area in which we're asking about the defendant's reasonableness, like the reasonableness of a mistake, right? Do we want to say in the person's position, or a reasonable woman in that position? Do we want to call the fact finder's attention to subjective, individualized, intrinsic factors to that person, whether it's the victim or the defendant, whoever it is, to allow the fact finder to guide the fact finder, maybe push the fact finder into taking into account their individual circumstances and experiences that the juror may not share. Right? A juror in a case of Bader-Women syndrome, where a woman is being prosecuted for some act of maybe assault or murder, may not have ever experienced abuse. And if you don't say, look at it whether it was reasonable from the point of view of a woman who has been in this relationship, as you find the relationship to be, will the jury naturally just go in the direction of considering that, or will those factors not get considered? Okay, so this question of reasonableness and how much of a subjective component, if at all, should enter into that is a big question. Okay? Questions about Lighthome, Bader-Women syndrome, any of that? Yeah.
Is there a majority
Oh,
regarding
yes.
subjectivity, objectivity?
Well, I think the majority certainly takes subjective into account in some way. How they do it varies, right? Sometimes it's very much made very subjective, and is made in turn. The juries are instructed that they should use a reasonable woman test, and it should be a reasonable woman in the position of the defendant, that is, who's been in the relationship. Now, the jury may not buy there's been an abusive relationship. That's a fact question. But if the jury finds there's been an abusive relationship, the jury may then be guided by the instructions to say a reasonable woman who has been battered in the way, or been in the abusive relationship with the qualities this has had. Some states go that far. Some just leave it at a reasonable person in the position that the defendant was in, and let the jury make of that what it will. Okay? Then you get states like North Carolina, which is in the notes on page 574, note 2, where in Norman, they rejected it completely. Rejected the use of self-defense, even imperfect self-defense, even as a mitigation in the case of a sleeping batterer. And that was a particularly egregious abusive relationship, and yet the court completely rejected it. So that's one of the extremes too. Okay? Yeah.
Apart from insanity, is mental illness ever a good defense in criminal law?
Well, there's diminished capacity, which can be mitigation. So yes, but if mental illness does not render you not responsible for your actions, which is what insanity does, because you either cannot appreciate the wrongfulness of your conduct, or you can't conform your behavior to the law. You won't, but can't. That's what insanity requires under the current standard. Then you are responsible, even if you're mentally ill, right? There's some people who a jury might believe they were, to use the vernacular, they were crazy, but not insane in the way that the law excuses them, because they were able to appreciate the wrongfulness of their conduct, right? So they may suffer from a mental illness, and the prosecutor may concede that. Prosecutor may concede this person is mentally ill. They've been diagnosed, our expert agrees, but they still understood that what they were doing was wrong, so the law doesn't excuse their behavior. That, by the way, is all we will cover in that little 45-second treatment. That's all we're doing on insanity. And we came in response to a question. Okay? Now, I want to tell you that the professor who taught me criminal law would be rolling over, and probably is right now, rolling over in his grave. That is all we were doing on insanity, because he actually wrote the book on the insanity defense, or at least a book on the insanity defense, and made it a huge portion of the criminal law class that I took. But we just don't have time for it. It's obviously it arises in particular cases, but it's a judgment call what you're going to cover and what you have to leave out. So I've always felt guilty about that because of how I was taught criminal law, but I've had to disappoint a former professor. It happens. It happens. Okay, did I see your hand, Inspector?
Yeah, I had a question about if somebody was being held captive, which is what this makes me think of, sort of. The woman feels like she's being held captive. If somebody's being held captive legitimately, and they have the opportunity to kill the person that's holding them captive, would it not be considered self-defense unless at that moment they were being threatened physically or something?
If they're being held captive.
Yeah,
That'd make an awesome hypothetical for an exam. So if you happen to see it on the exam, blame Ms. Richter. She brought that on all of you. I have not thought of that. I think if I were the defense attorney in that case, I would certainly make that analogy to battered women syndrome cases, that people in those relationships certainly perceive themselves as captive to the abuse, to the relationship, as having no out, no way to get out other than violence, other than using force. And that if we're going to accept that sort of captivity by domination, then we should certainly, and give it and make it a form of self-defense, we should also make actual physical captivity the basis for self-defense. But I think that would be a very interesting question, or at least part of a question. And I have not done any research on whether there are cases of that kind out there. I think there's maybe a good reason for that, which is, let's say you have a real situation, which you have a Silence of the Lambs type situation, right? That's what, she was being held, the senator's daughter was being held captive. I cannot imagine the prosecutor who would bring those charges against the captive who escapes by killing the kidnapper, right? I mean, I guess it could happen if the prosecutor just didn't believe it. If the prosecutor believed that the defendant was making up the story of captivity. But let's assume that that's what we actually have, and the prosecutor believes it. I just don't think prosecutors bring those cases. So I'm not sure you'd ever see it to test that theory. But that's what law school hypos are about. The things that never happen in real life, but you get to write about them in a hypo. some of you may take some solace from the fact that last night I had to answer a law school hypo. Now I saw it in advance, so it was a little cheating, but I did a panel at the Brandeis Inns of Court, which I'm not going to get into the details of what that is, but it's a group for lawyers in town plus law students. Sort of they meet every so often, and last night the panel was on obstruction of justice, and they gave us a hypo that we had to discuss how the law would apply, how a lawyer would handle this case, that kind of thing. And I could not help but feel like I was being put back in law school and having to answer an actual hypo with all the outlandish facts that come along with it. And fortunately, A, I didn't have to do it alone. We have to do it on an exam. And B, I had several weeks to look at it and think about it. So it wasn't